Welcome back to the Conveyance Desk. In episode 5, we covered banks and managers' checks. In episode 6, we covered timelines, what fast looks like, and what is controllable. Today is episode 7, and this one is about the seller side. What sellers need to prepare, what surprises them, and how to stay ready when the buyer side is the bottleneck. Quick reminder, this is general educational content, not legal advice. Every transfer has variables, developer rules, financing terms, authority requirements. So use this as a guide, then validate your own case. Here is the framing. In most transfers, the seller is not the slow party. The buyer is, because the buyer brings the money, and money requires bank involvement. And bank involvement creates timeline, but sellers still get caught off guard, because being not the bottleneck is not the same as having nothing to do. 1. The seller's actual workload. Sellers often think their job is simple. Sign the contract, hand over the keys, receive the check. In reality, the seller has a substantial workload. Title deed retrieval, mortgage discharge if applicable, and have a application with the developer, original document handover, utility account closure, service charge clearance, tenant handling if the unit is tenanted. None of this is hard in isolation, but all of it takes time, and all of it has to be done before the trustee appointment. A seller who starts these tasks late is a seller who delays the transfer, even when the buyer is ready. 2. Mortgage discharge on the seller side. If the seller has a mortgage on the property, that mortgage must be discharged before transfer. This is its own process, and it is often where seller side delays originate. The seller's bank issues a liability letter. The buyer side, or the seller side, settles the outstanding loan amount. The bank releases the original title deed. The bank issues a clearance letter. The DLD removes the mortgage from the title. Each step has a timeline, and each step has dependencies on the bank's internal pace. So a seller with a mortgage is, in effect, also dealing with bank pace, just on their own side. The mistake we see most often, sellers underestimate how long a discharge takes. They assume it is automatic once the loan is repaid. It is not. The bank has to process, verify, and issue paperwork that can take days or weeks. 3. The NOC application. The seller initiates the developer NOC. This is the no objection certificate, confirming the developer has no outstanding claims against the unit. The NOC checks for unpaid service charges, unpaid utilities tied to the developer, community fees, and any other claims the developer has registered. If anything is outstanding, the seller must clear it before the NOC is issued. The NOC also has a validity period. If the transfer does not happen within that period, the NOC must be renewed. Renewal is usually quick, but not free. So timing matters. A seller should not apply for the NOC before the buyer side is close to ready. Otherwise, the NOC may expire and need reissuing. But the seller should also not wait too long. If the buyer is ready and the NOC is not even applied for, the seller becomes the bottleneck. 4. Service charges and the surprise factor. Service charge clearance is where many sellers get surprised. The developer or owners association calculates the final service charge balance up to the transfer date. Any arrears must be cleared. Any prepaid amounts get refunded or transferred to the buyer. This sounds simple, but the calculation is sometimes wrong. Or the seller has forgotten an unpaid invoice from 2 years ago. Or there is a special assessment the seller did not know about. So the rule, get the final service charge statement early. Review it carefully. Resolve disputes before the transfer date, not on the transfer date. A service charge dispute discovered on transfer day stops the transfer. A dispute discovered 3 weeks early gets resolved without affecting the timeline. 5. The tenanted unit. If the unit is tenanted, the seller has additional considerations. The tenancy contract continues with the new owner unless legally terminated. The deposit is transferred to the buyer or refunded to the tenant. The tenant must be notified, and in some cases, the tenant has a right of first refusal that must be properly addressed. This is not optional. It is a legal requirement, and skipping it creates disputes after the transfer. A tenanted sale is not harder, but it does have more parts. Sellers selling tenanted units should plan for tenant communication early, not at the last minute. Tenants who feel ambushed are tenants who push back. Tenants who feel informed cooperate. 6. Original documents. The seller must hand over original documents at the trustee. Title deed, affection plan if applicable, original sale and purchase agreement from the original developer purchase, and in some cases the original passport copies used at registration. If any original is missing, it must be replaced before the transfer. Replacing a lost title deed is its own process, with its own timeline, and it requires reporting and an affidavit. So sellers should locate every original document early, before booking the appointment. This is one of the most preventable seller-side delays, and one of the most common. People put documents away in safe places, and then forget which safe place. 3 weeks before transfer is the time to find them, not 3 days before. 7. Utilities and account closure. This is the tail end of the seller's workload. GOA accounts, cooling provider accounts, internet and TV, community access cards. These need to be closed or transferred at handover. Final bills paid. Deposits refunded where applicable. The risk if this is not done. The seller's name remains on accounts after they no longer own the property, which means future bills go to the seller, or worse, defaults on the seller's record. So treat utility closure as part of the transfer, not as something to deal with afterwards. 8. The ready and waiting position. The best seller side position is what we call ready and waiting. Title deed retrieved. NO key ready or close to ready. Service charges cleared. Tenant arrangements settled, originals organized, mortgage discharge in progress if applicable. Utility transfer plan agreed. A ready seller is a fast seller, even if the buyer side is slow, because when the buyer side finally moves, there is no seller side delay added on top. 9. Closing. The seller is rarely the slowest party, but the seller can still be a delay multiplier if not prepared. The discipline is to prepare in parallel with the buyer side, not to wait until the buyer is ready and then start. That is how you avoid being the surprise reason a transfer slips. In the next episode, we will cover overseas parties, buyers or sellers who are not in the UAE during the transfer, what that requires, and the role of power of attorney in those cases. That's all for today. This was the Conveyance Desk.